Hello, everyone. Welcome to our Back to Homeschool series. My name is Laura Gonzalez. I am a realtor based in San Diego, California, and I am passionate about making education on wealth and smart living accessible to all, which is why I've created this online series just for you. Tonight's guest, very special guest, is going to talk to us about how can we protect our assets and secure our family's future. So Aisha Williams is a estate planning lawyer. And Alicia, could you please introduce yourself?
Sure. Hi, everyone. Thanks for joining us tonight. My name is Aisha Williams. I'm an attorney licensed in California, based in San Diego, and we help individuals and families protect their legacies, their assets, their family, their kids through comprehensive, heart-driven foundational estate planning. I think Laura and I will get into what that actually means when we start talking. And we also do help families after someone's become incapacitated or passed away through trust administration or probate, which is what we're trying to avoid with the comprehensive estate planning. I'm also trilingual, so I work with clients in English, Spanish, and Portuguese.
Love that. We are so thrilled to have you, Aisha. Thank you so much for being on with us. And we want to start with the basics. Please tell us the most important question. What is estate planning and why is it so essential for us and our families?
The term estate planning can mean a few different things to different people. It's most commonly known as like a set of documents that will hopefully protect you if you become incapacitated and protect your assets from probate after you pass away. But I like to call it something a little different. I do life and legacy planning, which is a little bit more comprehensive version of estate planning, where not only are you getting the documents that you need, these legal documents that are going to protect your family, minimize the risk of conflict, reduce the chances of having your family have to go to court. But there's also some additional documents that we like to include to create some really robust protection plans. And there's a number of different services that we think are really, really important to include in this process so that your plan actually works the way that you intend it to work. In my experience, traditional estate planning, which is just kind of the basics, like a will, a trust, a power of attorney, healthcare directive, it's not enough. We have to plan. It's much more than just those basic documents. And so I just see in my administration practice doing trust administrations after someone's passed away or after someone's become incapacitated, or helping people, loved ones surviving, family members through probate when their loved one has passed away and they had assets in their name. I just see a lot of failed estate plans. And so that's something that I hope that by the end of our time together tonight, I've helped everybody understand a little bit the difference between kind of the basic traditional estate planning and the risks that that entails versus the more kind of comprehensive, very thoughtful estate planning that we do when we help our clients with life and legacy planning.
Thank you. So let's get into a little bit more of the details. Many people think that estate planning is just for the wealthy, or if you have all of these assets that you need to take care of. So why is it essential for everybody to consider it? And can you give us more details as far as what is included in a estate plan?
Yeah, it's a really common myth. The truth is everybody has an estate plan already. Everybody's subject to their state here in California. So I'm licensed in California, and everything I'm sharing with you all tonight is for educational purposes only. None of this is legal advice. But here in California, we are all subject to California's default estate plan. And that, for most people, not everybody, but for most people, is going to involve court. And court here in California is very expensive. It takes a very long time. Everything's public. If your assets have to go through probate court, they're going to be frozen, and your loved ones aren't going to have any access to them until the court appoints somebody as either the executor if you have a will of your estate, or the administrator of your estate if you don't have a will. So yeah, it's a very unfortunate situation when people have to go through probate, but honestly, most people go through probate here in California because only 30% of the population have any sort of estate planning done. And generally I would say a large amount of those estate plans are out of date. Their assets aren't properly funded. We use the term trust funding, which I can get into a little later, which means your trust owns your assets. And so I see a lot of partially funded trusts or totally empty trusts. And that's how, people who think they are protected and who think they've, put a plan in place can end up in a very vulnerable position because they've got this false sense of security. So we all have a plan, and we're all at risk of this plan. And, I tell clients that if there's a few triggers for whether your estate plan is going to include something called a revocable living trust. You might have heard that term. A revocable living trust is pretty common here in California because you need one in certain triggers. If you own real estate, you need a trust because probate is triggered by real estate that is valued at $50,000 or more. Obviously, here in California, I've never seen property valued at less than $50,000. So any real estate, if you don't have a surviving spouse, or if you both pass away at the same time, spouses drive together. So car accidents are quite common. That's how a house gets into probate. If you have minor kids, doesn't matter how many assets you have. If you have any number of assets, but you have minor kids, you need a trust to gift your assets to those children as their inheritance, because otherwise the surviving spouse has to go to court and get something called a guardianship of the estate for their own children. Right. So I've been seeing this a lot lately. And it's coming up in these very, very unfortunate situations where there's very low value assets. For example, just today, I had somebody with a $4,000 car. That's it. And the mother, so the parents were divorced, but the mother of the surviving child is now going to have to go to court and get a guardianship, because it's a minor child, a guardianship of the estate for her own son in order to even sign a document for the DMV to take custody of the vehicle so she can sell it. It's so homes, real estate, minor kids, if you own a business, if you have an LLC, if you have a corporation, you need to own that through a trust so that your business doesn't have to stop completely if you become incapacitated or if you pass away. So it doesn't matter how many assets you have. If you have any of those triggers, you absolutely need an estate plan that includes a revocable living trust. And then if you have enough assets, maybe you don't have any of those triggers, but you have assets in your name that are valued total, the fair market value on the date of death. That's what the court's looking at. What is the fair market value on your date of death of the aggregate of all your assets that are in your name, that don't have beneficiary designations, that aren't jointly owned, and that aren't owned in your trust? If they are currently, and every year it changes, currently in California, the threshold is $184,500. It adds up pretty quickly. So that's the other trigger. So there's like kind of 4 major triggers that we're looking for when we're trying to give guidance to clients on whether their plan should include a trust. But even young adults need a plan. Their plan may not include a revocable living trust. They may need just some very basic incapacity planning documents. So for the families with young adults or teenagers who are about to launch and go to college, they need a financial power of attorney. They need a healthcare directive and a HIPAA waiver so that if something happens to them, the family can step in and help, right? Because otherwise they have no legal authority to step in and help a legal adult. And then for minor children, we go above and beyond with our foundational comprehensive estate plans, and we prepare something called a kids protection plan. Typically what you'll see with traditional estate planning, which is why I like to draw this distinction between traditional estate planning and life and legacy planning, you only nominate guardians in the will. We go well beyond that, and we do standalone guardian nominations. We do emergency guardian nominations, important healthcare information, medical powers of attorney, emergency contact info, guardian instructions. There's a lot, caregiver instructions. There's a lot that we include. So even your kids need a plan of some sort. So everybody needs planning, right? It's just everyone's plan is going to look a little bit different.
Yeah, thank you. I mean, obviously those are many details that kind of confirms, like, if you are a living person, you most likely need a plan.
Yes, you need something.
So, yeah, you need something. And I think the huge misconception there is like, oh, I'm fine because I don't own anything. And it's like, if you are living and you're a human being, you're going to need some type of plan, and it's very much custom to who you are and your situation. So there is the term trust in will, and you kind of alluded to them.
Mhm.
Please just quickly define what they are and differences, because I think there's some.
Yeah, this is a big one.
Yep.
This is another very, very common myth that we see a lot in estate planning. A lot of people think, oh, well, I have a will, or my mom or dad have a will, so I'm not worried about what happens if after they pass away. Well, where there is a will, there is a probate. Wills have to go through probate. They just tell the court and the judge who you want to get your assets, in what shares. I want this person to get this account, or I want to split my estate this many ways with this many people, and who you nominate as the executor of your will, which is basically who's going to take your estate through the probate court process. That's essentially what a will does, but it goes through probate. So wills do not avoid probate. They literally go through probate. A revocable living trust is a little different. It's a way to bypass the probate process. It's really just an agreement between you as the creator or the trust maker of your trust, and then with you as the trustee. You guys might have heard the term a trustee. A trustee is just a trust asset manager, so they have authority to manage all the assets that are owned by the trust, and for your benefit. If we're doing a revocable living trust, you're creating it, you're usually the initial trustee, and you're the lifetime beneficiary. And then you designate people to step into your shoes as beneficiary after you've passed away. So if you're married with kids, the surviving spouse is usually going to be the next beneficiary. And then when they pass away, usually you're going to name your kids as your beneficiaries after both of you have passed away. And what you have to do, though, and this is where a lot of plans fail, and unfortunately, this is because just traditionally estate planning law firms and attorneys, in my experience, just don't spend a lot of time educating their clients about the importance of trust funding. And that is where, well, your trust is essentially like an empty suitcase. I like to visualize just an empty suitcase. I could make the most beautiful, fancy Hermes bag of suitcases, but it's useless if you don't actually put things in it. So you have to go to the bank and you tell the banker, I have a new trust. I'd like to put my checking and savings account into my trust, and they'll help you go through that process. And then we help you put your real estate, your business interests. And I teach clients exactly what to do with every single one of their assets, how to change beneficiary designations for retirement accounts or life insurance policies.
Yeah. So basically a will is just a starting point, if anything.
And when you have a revocable living trust, it's a backup plan. So our revocable living trust packages actually include wills, but the goal is to not use the will. The goal is that we have a trust, it's fully funded. We don't need to rely on that will. The will is just there as a backup plan, just in case you bought a new asset, forgot to put it in your trust before something happened, right? So it tells the court, please put these assets that have to go through probate now because we didn't get to put them in the trust in time, please put them in the trust. So it's a different type of will that we include with the trust packages. It's called a pour over will. So it just kind of like gifts everything to the trust. So if you've got kids, your kids aren't going to get everything outright at 18. They're going to get everything through the trust.
Yeah. Could you please just quickly define probate? Because I know that's a term.
Yeah. So probate is a term that a lot of people have heard, but don't quite understand what it means. So probate court is the court that sees and hears these matters of someone's estate. So when someone dies and they have real estate worth more than $50,000, they have aggregate assets in their name that didn't have beneficiary designations, or a surviving joint owner, or assets in a trust, and the total of the fair market value of all those assets is over $184,500, and that changes every year or two, then your estate, those assets have to go through the probate court process. And if you don't have a will, those assets are subject to California's default rules about who gets what. And you may not like those rules. Generally, for community property, if you're married, your surviving spouse will get them, but they may actually have to go to court to claim them if they're in the deceased spouse's name alone. What a pain in the butt. And it's totally avoidable when you have a plan in place, when you work with an attorney to guide you through how to do that. Probate court, like I mentioned before, is very expensive. So let me give you just a quick example of how expensive it can get. If you own real estate that has a fair market value on your date of death of $1 million, which is not totally unrealistic here in California. It's actually a lot of homes here are valued at a minimum $1 million. That is $23,000 for the attorney taking the case through the probate, $23,000 for the administrator of the estate, hundreds and actually by the end closer to thousands of dollars in court filing fees. You have to pay the probate referee who do the valuations for the appreciated assets. There are bond fees. If you don't have a will that waives a bond for your executor, your administrator, because there's no will, so they're called an administrator, they have to pay a bond. And now because this isn't somebody that you've told the court, I trust this person in my will, right? So this is somebody who's just stepping up. I mean, a creditor could technically be an administrator of a estate, right? Your ex-spouse who you owed money to can go become the creditor of your estate, can be an administrator of your estate. And it takes a minimum of 1.5 years, on average, well over 2 years, because every time there's an objection or something messy happens, and probates are just like inherently messy because there was no plan, right? So it's super common for this to happen. The court has to set a new hearing date, and that's usually 2, 3, in some cases 6 months out. I have a friend up in LA, and she's getting hearing dates 6 months from the date that she's filing the court documents. So it takes a really long time, and your assets have to be frozen. Your kids are going to get everything outright at 18 years old. Surviving parents or someone is going to have to petition a court to be a guardian of the estate for that minor child. It's just a huge hassle.
Yeah. What a nightmare, and a costly nightmare that can be
Yes.
be avoided by just having a conversation and planning.
Yeah.
With an attorney, somebody like you. Thank you for sharing that. And thank you. I love the personal stories that you're sharing about clients, because I think that makes it even more just relevant for our audience.
Yeah, I've been seeing a lot of sad cases, and honestly, just in the past couple weeks, with guardianships of the estate for minor children required for vehicles. And if those, and this is without even a probate. So if you even have tiny, very small estates, or where all the beneficiary designations worked, but there's this vehicle, the DMV here in California actually has a pretty straightforward processes for transferring things if you have a plan. But if you don't have a plan, it can get real messy real quick, especially if you are married and have separate property, because the default rules, I mentioned the California or the community property default rule. If you don't have a will, your surviving spouse gets your community property. But what about separate property? If you were married, if you had assets before you were married, or you were gifted or received an inheritance during marriage, that's a separate property asset. Your separate property is divvied up depending on who survives you. If you've got a surviving spouse, they're going to get either half or a third of the separate property asset, and you're going to have to share it with potentially your own children, right? It doesn't just go to you outright. You may even have to share it, if you don't have kids, with your deceased spouse's parents or siblings. So the default California rules, it's like they try to do as good a job as possible to, figure out who makes the most sense to give someone's assets to after they've died and didn't make a plan. But it's honestly not what most of us would want, right? Which is why you have to document it properly in a will, and even better, in a trust.
Yeah. And even if they, they do have the default kind of transfers, or the people that it goes to, it's still so costly for the whole family.
Depending on how those assets are owned, absolutely. They may have to go to court, even if they have the surviving spouse, and even if everything's community property.
Yep. So for estate planning, can you tell us how you can minimize estate taxes when you're transferring, assets to other family members, and how that helps?
Well, I have good news if you're in California. California does not have an estate tax. Yay, California. Yay for us. But we do have to contend with the federal estate tax. And currently it's very, very high. So it's really not an issue for most people. We're almost at 13 million estate tax exemption per person. So that means, and they're looking at the net, right? When I talked about probate, we were looking at the gross value of the assets that would go through probate when the court is making their calculations. When it comes to estate taxes, we're not looking at the gross, we're looking at the net value that would be distributed to your people, to your loved ones. And then every dollar over that exemption amount, over that almost 13 million amount per person, gets taxed at a really high rate of 40%. So it's not an issue for most people, but for those people that it is an issue for, there are some very basic tools that we can include in your revocable living trust. We do mandatory splitting of the estates, and we create these other irrevocable trusts. It gets quite complicated. I like drawing it out for clients so you guys can see kind of like a flow chart of like where your assets go. But essentially a deceased spouse, instead of just gifting everything to their spouse outright, or in their survivor's trust that they have full control over, they can gift to their surviving spouse in these irrevocable trusts that have tax advantages. And there's ways to minimize your estate taxes by gifting that way. Another really easy way is making lifetime gifts. Currently, you can gift up to $17,000 per person per year. And so that is a very legitimate, very used tax saving estate tax minimization strategy used by people who are close to the estate tax exemption. One thing I'd like to mention before we move on to the next question is that the estate tax exemption is actually it's set to sunset. This would actually be the first time this happens in the history of the United States. It's always gone up. But it is set to sunset at the beginning of 2026, back down to the pre-Trump tax rate amounts, and it's going to go back to $5 million, but it'll be adjusted for inflation. So we're all looking at probably somewhere close to 7 million, unless Congress acts, but they can't seem to act on anything lately. So I don't know how realistic it is that they're going to kind of swoop in and agree to stop it from sunsetting. When I say sunsetting, it means it's just automatic.
Okay, so we will have to wait and see.
Mm-hmm.
I think you alluded to this a little bit earlier, but for a blended family, so you're remarried, have a new family, but you still have your other family. Can you talk to us about the dynamics of that and what to consider when you're at that point?
Yes. Oh my goodness. Blended families are very, very vulnerable to court and conflict. And their planning is usually a little bit more complex. It usually takes a little bit longer to design everything. There are some, I have some good ideas for how we can make gifts to your bio kids and still take care of your spouse. The same estate tax minimization tools that I was describing, where you gift to your surviving spouse in these irrevocable trust or trusts, that can also be used to protect or kind of like create a funnel that goes to your kids. So your surviving spouse still has access to your trust, but your ultimate beneficiaries are going to be your kids, as opposed to gifting everything to your new spouse and then they get remarried. If you passed away and something happened to you, perhaps they get remarried and now they have more kids with this new spouse, and all your assets are going to go to that new marriage and perhaps those other kids. You may want to make sure, as the parent of these bio kids, that you've created a funnel so that instead of everything going to your surviving spouse and then they do whatever they want with it, you create some rules and some guidelines to provide for them, and also make sure whatever's left goes to your kids. I also like encouraging a gift off the top to your bio kids at the first death. That way your kids aren't waiting around for a step parent to pass away before they receive an inheritance from you. So there's a lot to discuss. I just did a plan like this the other day. It was quite a long design session, but it's also kind of fun and creative. We get creative with how we're designing things, but family dynamics play a really important part in how to design your plan.
Yep. Thank you. And I think to that, can you just quickly take us through that? I know it's a lot of details, but the journey that somebody goes through when they work with, a team, as far as the beginning stages.
Sure. I'll try to do this in a quick nutshell. This is really one of the things that distinguishes the way that we do estate planning from the way that a lot of other law firms do estate planning. With traditional estate planning, you might meet really briefly with a lawyer and then you get handed off to a paralegal. You may or may not design your plan with a lawyer. For example, my parents met for 30 minutes with this lawyer. And then they were handed off to the paralegal. They designed their whole plan just by filling out a questionnaire. There was no education, there was no guidance, there was no hand-holding, there was no pros and cons of these options versus those options, none of that. And then they immediately drafted, they signed within just a couple of weeks and were given their documents, and that was that. They literally never heard from their lawyer again. This has been 20 years since they never heard from their lawyer again. So I looked at their plan. They weren't on speaking terms with the people that they'd nominated for important jobs. Their trust was totally empty. And so those are the risks of going with kind of the old school traditional estate planning model. Our life and legacy estate planning model is quite different. It's pretty comprehensive. You're spending 5 to 7 hours with me on Zoom. We're a virtual law practice, so we really make it easy for you to go in depth, do it right the first time so it works when you need it to work. But we break it up into like bite-sized pieces. So we're never overwhelming you with too much at once, but it takes some time to do it right. So we start with a 15-minute free consultation where we explain our process. We explain how we do estate planning, the difference between the way we do it and a lot of other firms do it. And we see if, we're in a position to help you and our legal services are appropriate for you and whether it's a good fit for everybody. And then next step would be a planning session with me. We call them family wealth planning sessions. They're 1 to 2 hour working meeting with me where I'm going to educate you about California's laws. I'm going to help you understand how you are currently vulnerable, like how it applies to your life, what a probate would cost you after looking at all your assets. We're going to talk about family dynamics. We're going to talk about your planning goals, and then we're going to come up with a tentative plan for what your estate plan is going to look like. And then if we engage, we move on to the next step, then we design your plan. And that usually takes anywhere from 1 to 3 hours. I would say most single people, we can design within an hour to an hour and a half. Most married people, we're looking at closer to 1.5 to 2 hours, blended families, closer to 3. And then we create a summary of your big design decisions. And we want you to sit with it. We want you to feel really comfortable with it. We want you to be able to change your mind. We want you to be able to ask questions, especially because there's different ways to gift to your spouse. There's different ways to gift to your kids, to your people. So we need to make sure that you're really good with all your choices. And then once you confirm, we start drafting your documents. We do a draft review meeting where I review all the documents with you. I explain how they all work. I explain the purpose of everyone. I want you to understand to some degree what it is that you're signing. You don't need to be an expert in this. This is why you've hired an attorney. But I want you to understand, at least at a high level, so that you know what you're signing your name on. And you're going to be much better at issue spotting your life as things change, as you move forward in your life. You're going to be much better prepared to know, oh, that's something that might impact my plan, or that is definitely something that impacts my plan. I got to call Aisha. And then we're going to schedule a signing appointment and we're going to send a notary to your home so you can get this whole process done from the comfort of your home, at your office, wherever you'd like to do this. Sometimes we see spouses where one's in an office and one's at home. We make it really convenient for you. And our notaries are super competent. They run the whole thing. You just do exactly what they say, and we make it really easy for you. And then we process everything, scan everything, and then we do a trust funding review meeting. This is critical, and this is where most traditional estate planning processes fail, in my opinion. We create a comprehensive toolkit to guide you through that process. And then I meet with you one-on-one to review every page of the toolkit, every asset that you own. I tell you exactly what you need to do with it. And then we give you 90 days of trust funding support. And we follow up with you. We want to make sure it actually gets done. And then we prepare your final portfolio. We ship it to you. And here's the big one. This is the 4th of the 4 stages: design, sign, fund your trust. 4, this is another place where so many plans fail: maintain. My parents did not maintain their plan. They stuck it in a drawer, literally. But they made a very, very big mistake. You have to maintain your plan. Laws will change. Best practices will change. Your life will change. Your assets will change. People get married. Kids get older. There's so many things that can trigger the need to tweak a plan or make a very big change in a plan.
Yeah. Wow. Thank you for sharing all of that. I think we're going to take a few questions from the audience. How often do you recommend to update your trust based on the fact you just mentioned life changes? So great question.
Yeah. And we include as part of our service, we reach out to clients every 3 years and offer a free meeting to just chat about your life, where I'm just going to issue spot and see if there's any. Did you start a new job? Did you get a new 401k? Did you update beneficiary designations? Did you refinance your house? Are you sure that you put it back in your trust? Because a lot of lenders pull it out and don't put it back in. Did they put it back right? Did they take it out as joint tenants and put it back as joint tenants instead of community property? Maybe that's a good time to mention that little nugget. If you're married and you own your property jointly with a spouse, if you own it as joint tenants, you are exposing a surviving spouse to major capital gains taxes. The correct way to take title when you are married and you own jointly is community property with right of survivorship, and then put it in your trust. Or if you have a trust, just take it into your trust as trustees, and there's a presumption that it's community property. Don't do joint tenants if you're married. Don't do it. What was the other question?
About how often they should maintain it.
Yeah. Okay. Every 3 years, right? So I'm looking at things that changed in your life. However, you may recognize that, oh, Aisha kind of taught me about this. This sounds like it might trigger an update. Let me reach out to her. Something to keep in mind, though, is that you want to refresh your financial power of attorney every 5 to 10 years. Banks can get really stingy about accepting a power of attorney if it's older than 5 or 10 years. That's the range where I would start pushing. So when we're at like the 9-year review, that's when I'm really going to encourage clients to, at the very least, refresh their financial powers of attorney.
Great. Well, the point is, don't stick it in a drawer and never look at it again.
No, I want you to think about this on a yearly basis. Honestly, once a year, just take a inventory of your life and think if anything has changed, that, major life changes, new job, new house, new business, new accounts, new assets.
Baby, all of those things.
Huge, absolutely. Babies,
For growing
marriages.
It's almost like you're probably going to do that maintenance more often. So
yes.
Thank you for answering that. If I am a single individual with no children, do you still recommend a revocable living trust? And if so, why?
It depends. If you don't have any of the triggers that are going to send you to probate, then no. But if you have enough assets that could go through probate, then yes. If you own a home, absolutely. If you own real estate, absolutely. So again, it depends. It's like that typical lawyer answer. So that's why that family wealth planning session is so important, because I'm looking at what are your plan. You may have nieces and nephews that you want to gift to, even if you don't have the threshold of 184,500, you don't own real estate, but you want to gift to your nieces and nephews. I have a lot of single clients who gift to nieces and nephews. Don't name your minor kids, children, nieces and nephews as beneficiaries. You're going to send an adult to have to go to guardianship court for them, right? Don't name minors as beneficiaries on any accounts. It's got to go through a trust. So you name your trust, and then your trust makes the gifts and holds on to those assets until they're old enough.
Gotcha. Does this same person ask, does the revocable living trust identify who the assets go to, hence not needing a will? Am I understanding correctly?
It will. That's what the trust does. However, you always want a will as a backup. So you never do a trust without a will. Absolutely not. If a lawyer did that, that is malpractice. This is why you got to work with a lawyer. Don't DIY it. There's so much to this practice area. There's so many ways to mess up and to make mistakes. I've seen horror stories where people accidentally disinherited their kids instead of gifting to their kids because they DIY'd it. You need a lawyer to guide you through this because there's so much to it.
Yeah. Thank you so much, Aisha. I think just to wrap up, because we have a lot of couples or clients who are recently engaged or are soon to be married. Why is this period right after a wedding such an optimal period to have your estate plan done?
Yeah, so we included a freebie for this that gives you some information about what you should do after you are recently married. You're going to want to update beneficiary designations to include your spouse. You may have had your friends or your parents included as your primary beneficiaries, but now you're married. So make sure you update your beneficiary designations. You may need a financial power of attorney, and you want to name your spouse because they don't have legal authority, even if you're married, to access your bank accounts and pay your bills if you get into an accident and you're in a car crash. So you need to tell the law, tell the banks, tell everybody through your financial power of attorney that you trust your spouse to step into your shoes and to be able to handle legal matters on your behalf and to be able to handle your assets and your debts and everything financial. And that's just not automatic. Otherwise, they may have to go to court, go through conservatorship court, which is what Britney Spears had. So that's kind of in the news a lot lately.
Yeah.
That's what you go if you become incapacitated. Even if you're married, your spouse may have to go to conservatorship court, and it costs thousands of dollars. It takes a long time. It's very stressful, and your financial life could kind of get ruined in the meantime. Same with a healthcare directive. Do you want your family fighting with your spouse about who's in charge and what your wishes were? There's a really sad story from the 90s about a woman named Terry Schiavo in that exact situation. And she was basically kept physically alive in a persistent vegetative state for over a decade because the parents and the husband kept fighting about it. A HIPAA waiver, that's another key component of a comprehensive estate plan. You want your medical team to be able to share private medical information with your people. So make sure that it's documented. Otherwise, they may not want to share it with your spouse, with your family. You got to document it. And if you've got minor kids, like I said, you may be coming into with a blended marriage. Then it's really, really important at that point because those things get messy very, very quickly. And just a revocable trust and a will are two really fundamental documents that you're going to want to get in place. Most people, after you get married, right? You're taking stock, you're taking inventory of your life, you're looking at your assets and who you want them to go to, and it changes after you get married.
Yeah. Yeah. Thank you so much. This has been so insightful. Again, so many great details. I think, what I can recommend to people is if you have an estate plan and you don't think it was done right for some reason, please reach out to Aisha. Or if you have no idea, this is the first time you're talking about or learning about estate planning, she has all the details, she has all the knowledge. And again, it's so custom to your situation and to your family situation. So feel free to reach out. We're going to send a recap of this conversation via email to everybody who attended and signed up, as well as the freebie that Aisha alluded to earlier. Thank you so much, Aisha. It was so great having you.
It was my pleasure. Thank you so much for having me. Get your plans in place.
Yes. Thank you, everybody.